Good morning, everyone, and happy Friday. We made it to the end of the week. Still got some 90-degree weather here in Chicago, but I am under the cold air conditioner at work right now. So I've had some requests to go over how to answer the questions regarding confidentiality, as well as the duty to warn and the duty to protect. So I'm going to take a deep dive into that this morning, and I'm going to try my best to explain this the way that I learned it and the best way that I know how. So the first thing about it is you need to first identify in the question which of the ethical principles are you going to be working with. One of the things about this is confidentiality is one of the main ones that you're going to see, and that's just not for LMFTs. That is for any counseling profession, right? That confidentiality is like one of the core ethical duties of what you should be doing in this profession. So one of the things that I used to always ask myself is, if I'm looking at a question, is this a duty to protect situation? Is there some harm going on, or is there self to some other people? You will be able to tell just by anything that's probably written in quotation marks, anything that sticks out that is a red flag that says like this person is like really saying they're going to hurt somebody or hurt themselves. That's what you need to pay attention to. Informed consent is also one of them. I've had people discussing and talking about the informed consent procedures, about confidentiality, and if a client is coming in and telling you, oh, they want to hurt themselves or they want to hurt somebody else, and you forgot to go over that, it is still your job to go over that component. It doesn't mean forget about it. You still have to go over it, and at the same time, do what? Protect the client and protect this other person. Regardless if you forgot to mention it to that client or not, you still have to do it, and you still have to make sure that this client is aware of this, even in that moment. Privileged communication, exact same thing. When do you have to break confidentiality when it comes to privileged communications? Those are the subpoenas. Those are the court orders and everything. Yes, when you see a question that's regarding any of these aspects, whether if you told the client or not, it's still your duty to do so, and you still have to protect that client or protect that other person that they may be talking about that they want to harm. Now, this is the thing. You have to know when you can breach confidentiality. There are some questions that are just like really like vague, especially when it comes to like self-harm or the duty to warn or protect. If it's too vague, then you're going to have to choose your response that says, try to find a better understanding of the intent of what's going on, right? So one of the things is be familiar with the exceptions to confidentiality. That's your mandated reporting. Child abuse, elder abuse, dependent adult abuse. Dangerous to self or others, that's a tear us off. That's a duty to warn or the duty to protect. Those are your exceptions to confidentiality. The court order or subpoena, you can't ignore those. Those are like a given. Even if it says a subpoena is coming from a lawyer, you can't ignore it. You're going to have to consult with your lawyer, right? Is there a legal or ethical obligation to breach confidentiality? Work your way through that question. If it is something that is just like alarming, imminent danger, imminent harm, then yes, you are going to have to breach confidentiality. And I also have a breakdown of that as well. Safety comes first. Prioritize the client's welfare. I know people probably get tired of hearing me saying this, but safety will always come first. Choose the option that is going to protect the client from harm. That also includes confidentiality. Protect that client's confidentiality. Our clients have a right to confidentiality. Our clients have the right to tell us like, hey, I think I might be pregnant. There's no reason for you to break confidentiality at that moment, but what you can do is go over options with that client or go over options with that teenager unless it poses harm. Now, if it's posing harm in the vignette and it's like really like something like catastrophic or whatever that's going on during the teenager pregnancy or whatever, then yes, but still pay attention to those red flags. One of the biggest things is trust. You have to maintain trust unless you really have to breach confidentiality. You don't want to break your trust with your clients because then it's going to do what? It's going to rupture the rapport that you have built with them. So please be mindful of when you think it is best for you to breach confidentiality. Here it is again. I know people are tired of hearing it, but I've had a lot of other people tell me like the red flag scenario has been working, because when you see those red flags, automatically you cannot ignore them. Process of elimination, ethical answers that justify the immediate breach of confidentiality without clear justification should always be like, well, I can't do that. If you don't have enough information in that vignette, then get rid of that answer. Get rid of it. If it's a low risk, 9 times out of 10, you won't have to breach confidentiality. You'll see something like explore more the intent behind what's going on before you have to breach confidentiality. Or if it's a risk for suicide ideation, you may look for a response that says something on the lines of maybe creating a safety plan. You have to know what it is that you're looking for in that vignette in order for you to make the best response. Eliminate answers that ignore potential harm or legal obligation. That's a huge red flag. Any answer that is telling you to ignore, or any answer that's telling you to avoid, or an answer that may say, oh, follow up with it the next session, avoid it. If it's imminent harm, you cannot wait until next week. You can't. You want to look for answer that involves what? Consulting, clarification, informed consent, unless the situation is urgent. If the situation is not urgent, you can consult, clarify, or talk about informed consent or whatever the case may be, which is why I'm saying if the vignette is very vague on a person saying they want to hurt somebody or something, you have to clarify. So that way you'll be able to tell if you need to trigger the duty to protect, the duty to warn. You want to avoid answers that breaches confidentiality without assessment or consultation first. In that vignette, you must have clear documentation that this person is going to hurt themselves or somebody else before you breach confidentiality, as well as when it comes to subpoenas and court orders and everything. Make sure you have enough information before you do so. Vague terms like I keep saying, assume, guess, or a response that says, I've seen a lot of responses on AATBS and Jerry Grossman that when something is going on with the client, when it comes to like harm or harming someone else, a response will be like, oh, tell the client to tell somebody else. No, we're not doing that. They're our client. So when we're in that session, we need to be helping them work through this, and at the same time you also need to be thinking about how ethically and legally you are going to respond to this situation. Avoid vague answers that says that. Avoid answers that is telling you to ignore, follow up next week, follow up next session, especially when you know that it is an imminent risk to someone else or to themselves. That is when you report. Here it is. Identify the type of confidentiality issue. This is ways how I worked myself through it. After a while, I started to learn when it came to confidentiality questions. Is the client a danger to themselves or others? Is there abuse? Is this court related? Is it about a third-party disclosure? When it comes to couples in therapy, I've had a lot of people ask me about the no secrets policy. This is not a state-specific exam. It's nationally. All of these questions are generalized. So assume that this client should know about the no secrets policy. And if they don't, then you still have to tell them about the no secrets policy if that response is included in one of the responses to a question they are asking you. When it comes to couples and a client is like, yeah, I had an affair with this woman, and this client emailed you and told you that, and they ask you like, oh, what is your best response or whatever. The response may say, oh, you have to disclose this like in the next session or whatever. I've seen responses that says that they will tell the client you must disclose this in the next session. I've seen responses that say that. I've also seen responses that say that the therapist is telling the client about their no secrets policy and they must disclose it, and they must disclose it themselves. But at no point should the therapist be disclosing that, because then that means what? You're breaching confidentiality. So that's another thing that you also have to consider when it comes to working with couples as well as minors. Minors has the right to confidentiality as well. If a minor is coming in telling you, oh, they think that they're pregnant, you can't tell their parents. It says they think that they're pregnant. You're just going to explore options with them and discuss it with them. There's no reason for you to breach confidentiality. I've seen a lot of questions that say that. Is it about record keeping or limits of confidentiality? Yes, also record keeping as well. When it comes to a client that is asking for their therapy notes, what can you do when they ask that? Do they have a right to their notes and stuff? Yes, they do. But at the same time, do you want to allow them to see it if it's going to pose harm to them? That's also another thing you think about. Think about always protect the client. If it is going to cause harm to release those notes, then you can say, hey, no. But I think there's also another process that you also have to take when you are doing that. Pay attention to what that vignette is asking you. Pay attention to the language in that vignette that they are using. And we will work through that as well. So here it is. Core ethical and legal standard. These are some of the things that you can look at. And this is how I learned myself. Is there a threat to self or others? Then yes, you need to be breaching confidentiality if it's imminent and it's serious. Make sure you have enough credible information in that vignette to do so. Child, elder, or dependent abuse. Yes, report is required. Make sure you have enough information in that vignette to do so. If it's vague, you know you're just not going to jump right over to do that. You're going to have to do what? Explore, get more information, unless you have enough. Or if that vignette says you suspect that is abuse, 9 times out of 10 the answer is going to be reported. Court subpoena, maybe you do that, but you have to consult with the client or a legal counsel first. Different questions come with different responses. So sometimes you may not get a response that says consult with the client, and it's just going to say consult legal counsel first. Now, here's the thing. If you were to get a question and both of those responses are on there, consult with the client, or it is another response that says consult with the legal counsel first, make sure you read that question specifically as to how you need to proceed. I have yet to see a question that does that, but make sure you read that question specifically and see how it reads and see exactly what it's asking you for, and that way it will lead you to your best answer, right? Consent that's given by the client, yes, with proper documentation. So this is again like if you need to have a release of information, especially if you're doing like family therapy and there is something that you want to disclose to the rest of the family, you're going to have to get a release of information in order to do so. And you're going to have proper documentation in order to do that, right? If risk is vague or hypothetical, no, you need to assess further first. Do not jump straight to breaching confidentiality without enough information to do so. Least harm and client center. So on the exam, you are going to do your best to protect the client's privacy by any means necessary, unless there is a clear reason to break it. I can't keep saying this enough, and I hope that it starts to stick. You are going to favor just assessment questions, consultation, or that clarification when breach isn't obviously required. And you will know when breach is not obviously required. You will be able to look at that vignette and be like, oh, there's no plan, there's no intent. What is it? What can I do at this moment, right? What can I do with my client? Probably create a safety plan with my client, right? Or I can clarify what their intent is, right? But don't just jump to breaking confidentiality too quickly. Read the vignette, see what it is that they're discussing, and then make your final response. Pay attention. Pay attention. Sometimes all of the questions are okay, and I know I've heard people saying it, but the best answer includes what? Depending on what that vignette says, it's going to include consultation. That's with the supervisor, that's legally, or the ethics board. Depending on what that vignette said, look for an answer that will include consultation with the supervisor, legally, or an ethics board, like an attorney or something, right? Client involvement, that is discussing the limits of confidentiality. Again, like I was saying, oh, I forgot to tell him about the limits of confidentiality in the informed consent or at the beginning of the therapy. Too bad, because now you got a situation here where he's saying that he's going to overdose on pills. Tell him anyways. If you see a question that says that, involve them in the limits of confidentiality. Step-by-step approach, no rash decision making. That is my thing when I say don't choose answers that is like out there, and it's like you don't have enough information for it. Don't add to the vignette that will also make you make rash decision making. When you add to the vignette, it means that your mind is like on this tangent and you're circling, because now you're probably putting yourself inside of this scenario, and you can't do that. No rash decision making. Do not jump to breaching confidentiality if you do not have enough information. Okay, now we're going to move on to how to recognize the duty to warn and protect in some of the questions, right? So, one of the main things is what I've been telling everybody. You need to recognize when you are to trigger the duty to warn and the duty to protect. You have to know when. You need a credible threat to an identifiable person. You have to have that identifiable person. It has to be serious. It has to be imminent. Sometimes there's going to be a means or plans. Sometimes it's just going to be a means. Sometimes it may be just, sometimes it might just be a means. But if it's a plan, then yes, you're going to activate that duty to warn and protect, right? If it's a means, sometimes it will include a means, but it has an identifiable person and there's a threat that they're making. So do you activate the duty to warn and the duty to protect? Yes, you do. Pay attention to what is worded in that vignette so that you know how to proceed. Okay, here we are again with these red flags. The red flags are flagging. I can't get over these. Client says he plans to kill his boss tomorrow. Okay, he has a plan. He plans to do it. If he's working with this guy, he knows where he works. So obviously he's going to go to work and he's going to kill him. Yes, we are activating the duty to warn and protect. Has a weapon and has tried to contact the victim. Yes, you're contacting the victim and you have a weapon. That tells me that you're trying to, move through this plan that you have in place. Client refuses to promise safety for themselves or other. That is when you are probably going to have to do involuntary hospitalization. So make sure if you see anything that says that they cannot promise safety for themselves or other people, probably going to be something about hospitalization. If there is a specific target and credible plan, the duty is likely to warn or protect. There is no way around it. And I have some questions that we can run through that I will do in another video to show you all how you work through those questions. But you also need to know your legal and ethical responsibilities. Depending on the severity of the threat, you are required to warn the potential victim, the law enforcement, or initiate hospitalization to ensure safety. That's what I mean when it says that they can't promise you that they won't do what it is that they're going to do. You might need to initiate hospitalization. You want to document everything. Consult with a supervisor or legal counsel if you are uncertain about anything. And your goal is preventing harm, even if it means breaking confidentiality. That is the biggest thing. We have to protect our clients, and we also have to protect other people that our clients are saying that they are going to harm by activating the duty to warn and the duty to protect. You want to choose the most ethically and legally sound options. Don't ignore those red flags. I can't get over these red flags. I want to make sure that these red flags are just flying and you guys are seeing these red flags and paying attention to them. Do not maintain confidentiality when there's a credible threat. You can't. If there is a credible threat, this person is telling you they have a suicide plan, they have a plan to kill somebody else. That means, I know what time, I know where, my boss gets off at this time, I know which parking garage he parks in, and I have a baseball bat with pins and stuff at the top of it or nails at the top of it or whatever. I am going to get him. Credible threat, yes, you need to report. Do assess the seriousness if it is unclear. If it is saying something like, I had this one question that said he was going to knock his boss's block off. Okay, well, what does that mean? That's all he said. He was going to knock his block off. It's unclear. So then what? You need to assess the seriousness. So you make sure if you have to report it or not. Do warn or protect if there's an imminent and identifiable threat. Don't ignore those identifiable threats. You can't. Somewhere in a response, you need to be paving way to that identifiable threats. Do consult if you are unsure. This often shows best practice on the exam. If you see a response that says that, then 9 times out of 10, that's going to be the right answer. Because probably the other 3 is like absurd, or it's probably you being rational, doing rash decisions, and you shouldn't be doing it in the first place based on the information that comes from the vignette. Don't ignore red flags. If you see a credible threat that's up there, anything that has to do with killing themselves, hurting somebody else, somewhere in their response, it needs to be paving way to those credible threats and those quotation marks that they might have, or any information that is saying a light bulb is going off. That vignette, if it states anything about how this person wants to do something to themselves or do something to somebody else, the answer response must pave way to what is being said in that vignette when it comes to duty to warn, duty to protect, harming themselves or harming somebody else, right? So this is when to breach confidentiality. Duty to warn and duty to protect. Clear threat to an identifiable person. Break confidentiality. Suicidal thoughts. No plan. You're going to assess, consult, or monitor, right? Suicidal with plan and means. You might need to hospitalize or ensure safety, meaning create a safety plan or something, depending on how that vignette is going to word it. The vignette might say something like, oh, they're refusing to do a safety plan. Then you know you need to do what? Involuntary hospitalize them, depending on what plan they have in place. If you have a vignette that says that this person has a suicidal plan already, you know that's breaching confidentiality. Vague anger towards others. Explore. Do not breach confidentiality. Don't jump over to breaching confidentiality if you do not have enough information. Court order or subpoena. Consult may be required to disclose anything. 9 times out of 10, when you get a court order or a subpoena, you're still going to have to talk to your own attorney or anybody that is legal that's in your corner to consult to find out what your next steps are. Okay? Clear threat to identifiable person. You gotta warn, protect, you gotta break confidentiality. Those thoughts with the no plan, assess, consult, create a safety plan. Low risk is not you breaking confidentiality. High risk is you breaking confidentiality. Low risk is like there's no intent, there's no mean, it's just passive. So now we're probably going to be making a safety plan with our client, finding some coping skills for them, things of that nature. Vague. Do not breach confidentiality. You don't have enough information. Okay? I hope this makes sense to everyone. I'm trying my best to make these videos as informative as I possibly can, but how are we feeling about confidentiality questions? And I'm going to go over some in my next video. Don't ignore red flags. You can't ignore the red flags. Pay attention to what that vignette is saying. If it's saying anything about killing somebody, hurting themselves, cutting themselves, overdosing, going to somebody else's house to hurt them, knowing where they work at in a job, having a plan to do anything, suicidal plan, somewhere in that response, it needs to pave way to what they are talking about in that vignette. And I'll show you what I mean in my questions. Know your legal and ethical responsibilities. You have to read your code of ethics. Read the code of ethics. It will teach you so much about your ethical and your legal responsibilities. It'll teach you so much, I promise you. That's how I learned. Choose answers that protect the client or others. You're always going to make sure that client welfare is top of your priority, as well as other people. Choose an answer that's going to protect them. I hope this video helped. I am going to do the video for how to answer confidentiality questions, as well as the duty to warn and protect. As always, leave a comment, leave a question, any concerns, message me, find me on Facebook. I am here to offer support. Happy Friday, everyone. I will see you later.